Good afternoon, my name is Irina Pereira dos Reis. Today I have the pleasure to discuss with Manon Hetsch, current student at the LLM in International and European Law at the Catholic University in Lille, about the trials in abstentia and procedural criminal law. There will be a special focus on this issue arising from an accused person, which is aware of the criminal charges against him, but has absconded before receiving official information about the subsequent trial. Thank you, Manon, for being here this afternoon.
Thank you for the invitation.
First, I would like to begin with a simple question. What is a trial conducted in abstentia, and how can you define what is an absconded person?
So trials in abstentia can be defined, as the wording can indicate, are trials that take place in the absence of the accused person. This legal concept is justified by the need to prevent the accused person from hindering for an indefinite period of time the defense of the victims affected by the offense. It also aims to prevent the impact of time on the integrity of evidence and the public proceedings. For example, memory can fade, the quality of evidence loses value. As for the definition of an absconded person, it can be defined as a person who runs away in order to avoid legal prosecution. For example, in the judgment rendered by the Court of Justice of the European Union in 2022, IR was accused of having participated in a criminal organization with a view to committing tax offenses punishable by custodial sentences. A first indictment by the Specialized Criminal Court of Bulgaria was served in person for IR. After the stage of the criminal proceedings started, even though IR indicated an address at which he could be summoned, he was still nowhere to be found, despite many attempts by the competent the Bulgarian national authorities. So, therefore, the National Court appointed a lawyer to represent IR during the proceedings, but it was found that this appointed lawyer never established contact with him. And since the first indictment was found with an irregularity, the ongoing proceeding had to stop, and a new indictment was drawn up, but was never served on IR in person. So the referring court concluded that IR had absconded and decided to conduct the trial in abstentia.
Okay, thank you for shedding a light in those legal terms and facts of the case. Before going into further details, can you explain briefly the issue at stake in the case at hand?
Of course. So first, let me say that trials in absentia are a frequent issue in criminal proceedings. What is particular about this judgment is that it is the first time the Fourth Chamber ruled on an issue arising, as you said, for the fact that a person has absconded before receiving official notification of his upcoming trial. So the main question on this case was whether the accused person could be entitled or not to a new trial. Indeed, based on the directive on the strengthening of certain aspects of the presumption of innocence and of the right to be present at the trial in criminal proceeding, either it is found that the accused person has deliberately and intentionally failed to fulfill his obligation to be informed of his trial. So on that account, the possibility for a new trial is precluded, and the National Court can enforce the decision without the possibility to challenge this decision. Or it is found that the accused person could not be informed of his trial because it was beyond his control or linked to legitimate reasons. Therefore, in this situation, the latter can be provided with a new trial. But since the Bulgarian judges were unsure which scope of application to apply in this situation, they lodged a request for a preliminary ruling to the Court of Justice of the European Union.
Okay, so what did the court argue in this case?
So in its case, the court argued and especially focused on whether IR had sufficient knowledge of the charges against him and the upcoming trial. You will see that this consideration of knowledge is crucial because it determines whether an individual is entitled or not to a new trial. As I mentioned earlier, the directive is structured in a dual logic. Nonetheless, the Advocate General, in his opinion, stated that the case of IR is in a gray area because it concerned a person who has not been informed of his trial for a reason which is attributable to them. It is not a situation explicitly covered by the directive, and this is for this reason the court introduced a new presumption where individuals who are aware of the trial but have not been officially informed can be tried in their absence. So the concept of awareness, as you can see, is essential. The court did not give any straight answer for this situation, but rather gave an interpretation of both possible situations in order to provide guidance for the Bulgarian court to assess the situation. Indeed, the judges declared that if the Bulgarian court found with precise and objective indicia that IR intentionally disrupt the receipt of the official document, the latter would be precluded from a new trial.
Okay, so to achieve this solution, did the court rely on other legal frameworks, or did the judges only rely on this directive and of the right to be present at a trial in criminal proceedings?
Yes, they rely on other framework. For example, they relied a lot on several judgments of the European Court of Human Rights. So, for example, they rely on the judgment of March 2006, Sedovic v. Italy. It was used to show that even in the absence of an official notification to inform the accused of the criminal charges against him, it is still possible to establish that the accused person has unequivocally waived his right to be at his trial. Therefore, if we follow this interpretation, the accused person is precluded from a new trial. On the other hand, the European Court of Human Rights stated in another more recent judgment in 2012 that even supposing that the applicant was indirectly aware of the criminal charges against him, it cannot be inferred that he unequivocally waived his right to appear at his trial. As a consequence, a new trial would be possible. But in the end, in the solution, the court leaves really much room for interpretation for national courts.
Okay. So, as you say that the court leaves much room for interpretation by national courts, how would a member state, in this case, Bulgarian courts, assess whether an accused person had actual knowledge of the upcoming trial against him?
So, as I say, since the EU legislator allows member states to assess the degree of awareness from the accused person, it encourages them to examine both the conduct of the competent national authorities in communicating the information, and also the conduct of the person concerned in receiving properly the information. So there is an obligation for national competent authorities to exercise due diligence by summoning the accused person properly, which means that they have to bring to the attention of the person concerned the date of the trial, the place of the trial, and make sure he has enough time to prepare his defense. And on the other hand, due diligence must also be exercised by the person concerned in receiving properly, as I said, the information.
Thank you. And what do you think will be the future of Europe in regard to this procedural, criminal law matter?
First, I think the implementation of this directive allows a fair balance between the margin of appreciation of national courts. So it allows the judges to ensure the effectiveness of the justice system, but also to ensure that every individual has the right to a fair trial. However, I think in the case of IR, the court lacks of clarification. It did not elucidate the threshold of knowledge the individual should have, know which kind of grounds was needed to assume a person has absconded. So I think it's likely National Court will continue seeking guidance and clarification to ensure consistency on this issue.
Thank you. Thank you for being here.
Thank you.
And see you next week for a new episode.